Bom dia a todos. Na Alemanha, boa noite. Nos Estados Unidos, para a Daphne, bom dia. E à tarde, no Brasil, boa tarde. A gente tem hoje uma constelação aqui nesse evento de 3 continentes, né? Na América Latina, nos Estados Unidos, na América do Norte e na Europa, com 3 fusos horários diferentes, né? E a gente tem uma grande honra de fechar a série de debates sobre desinformação e democracia em parceria com o Instituto Cultura e Democracia, monitor do debate público digital e com o apoio da organização internacional AVAS, uma série de eventos que teve como objetivo acompanhar os debates finais do projeto de lei brasileiro de regulação de redes sociais. E ele termina justamente agora com o fechamento dos trabalhos do grupo de trabalho na Câmara dos Deputados. E para a gente é uma grande honra estar nessa constelação, que é uma constelação que busca trazer experiência internacional para o debate brasileiro, com 2 grandes especialistas, tanto da Europa quanto dos Estados Unidos, que vão ser apresentados pelo Fernando Lottenberg, que hoje está aqui conosco para fazer a abertura e o fechamento dessa série de eventos, o que nos orgulha muito, Fernando. Fernando representa aqui uma das principais instituições brasileiras que estão presentes no debate sobre regulação de discurso de ódio, regulação de redes sociais, que é a CONIB. E para a gente, Fernando, é uma grande honra tê-lo aqui enquanto pessoa, tê-lo aqui enquanto representante institucional da CONIB. E vale lembrar da recente nomeação do Fernando para a OAS como um comissionário, né, para monitorar e combater o antissemitismo na Organização dos Estados da América, que é um cargo que foi apontado, nomeado pelo Luiz Almagro, né, que é um cargo que nos orgulha muito enquanto brasileiros e que tem certeza que vai trazer para as Américas, para os estados, para os membros da organização, um grande resultado na questão da regulação do discurso de ódio. Então, eu passo a palavra ao Fernando Lottenberg e agradeço já de antemão o tempo e a participação conosco.
Muito obrigado, Ricardo e amigos que compõem a mesa. Para mim é uma honra estar com vocês aqui nessa oportunidade de abrir essa última sessão e, na sequência, aprender com vocês um pouco mais sobre esse tema tão tormentoso. O fato é que, passados mais de 2.700 anos da criação do alfabeto, nós estamos em meio a uma transformação oriunda da tecnologia, uma das principais tecnologias criadas pela humanidade, que é a rede mundial de computadores, viabilizando a comunicação de pessoas e dispositivos conectados, seja na forma escrita, visual, auditiva ou figurativa, ou mesmo em conjunto. E esse cenário inédito, somado ao fato de que não somos mais apenas receptores passivos de informação, podendo ser sujeitos ativos individual ou coletivamente, gerando informação, produtos ou serviços, torna o quadro certamente mais complexo. Provavelmente não houve, na história da humanidade, uma outra invenção capaz de transformar em tão pouco tempo a interação e a comunicação de pessoas. Desenvolvida com base no princípio end-to-end, visando a que redes simples e aplicativos inteligentes possam agir de maneira fácil, transmitindo dados dos seus usuários de forma livre e neutra, em tese a internet serviria para permitir uma inovação contínua, a criação de conteúdo e a transmissão do conhecimento. Ocorre que a ausência de controles vem permitindo diversas possibilidades de sua utilização, às vezes com resultados positivos e outros nem tanto, né? Como não há interferência, em tese, no conteúdo dos pacotes de dados, a liberdade de expressão, a livre concorrência estaria garantido. Porém, se por um lado são evidentes os benefícios da liberdade e da ausência de controles na forma em que a rede foi estabelecida, por outro, como ela foi projetada sem discernir as variadas aplicações e o próprio conteúdo que por ela trafega em termos regulatórios, o end-to-end acaba por facilitar a atuação de agentes anônimos não autenticados, dificultando a sua identificação, bem como estimulando a criação e a disseminação de conteúdos ilícitos e maliciosos, por vezes em escala mundial. Podemos partir da definição de Wilfried Brugger do discurso de ódio como o conjunto de palavras que traz o potencial de insultar, intimidar ou assediar pessoas em virtude de sua raça, cor, etnicidade, nacionalidade, gênero ou religião, ou que tem a capacidade de instigar violência, ódio ou discriminação. Visando aperfeiçoar a precisão desse conceito, a doutrina criou diversas chaves de análise, tais como a estigmatização e a estereotipificação negativa de grupos sociais e o uso de expressões que em si denotam ódio e podem ser capazes de gerar ameaças à ordem pública, atos de incitação ao ódio a grupos ou a indivíduos identificados como grupos sociais e a negação de fatos históricos como o Holocausto, entre outros. A União Europeia já se debruçou sobre o tema e considerou como discurso de ódio determinados atos independentemente do meio pelo qual eles trafegam, tais como a incitação pública à violência ou ao ódio dirigido contra um grupo de pessoas, um membro de um desses grupos, definido com base nos parâmetros acima de raça, cor, religião, etc., a apologia, negação ou banalização grosseira de crimes de genocídio, de crimes contra a humanidade ou de crimes de guerra, e a instigação e a cumplicidade e a participação intencional na prática de um dos atos acima descritos. Entre nós, no continente americano, e aí já me valendo das novas funções que o Ricardo anunciou, o Pacto de São José da Costa Rica, nossa Convenção Interamericana de Direitos Humanos, prevê em seu artigo 13 que a lei deve proibir propagandas a favor da guerra, apologia ao ódio nacional, racial ou religioso, o que foi aperfeiçoado pela Carta Democrática da OEA de 2001. Entre nós, na Constituição brasileira, todos conhecemos no artigo 5º, inciso 42, sobre o caráter criminoso da prática do racismo, que o torna inafiançável e imprescritível, e, da mesma forma, nosso ordenamento jurídico infraconstitucional, por meio da Lei 7716, de 89, e as suas modificações posteriores de 97 e de 2001. Tivemos no Brasil um precedente fundamental para essa questão, decidido pelo Supremo no chamado caso Ellwanger, onde um editor neonazista e revisionista alegava que ele não poderia ser condenado por racismo, porque os judeus não são uma raça e, portanto, ele tinha a liberdade de expressão de divulgar pensamentos negacionistas e revisionistas. No entanto, o Supremo decidiu, a partir do voto do ministro Maurício Correia, que o preceito fundamental da liberdade de expressão não consagra o direito à incitação ao racismo, dado que um direito individual não pode constituir-se em salvaguarda de condutas ilícitas, como sucede com os delitos contra a honra. Prevalecem os princípios da dignidade da pessoa humana e da igualdade jurídica. Na CONIB, nós procuramos recentemente, com a ajuda da Escola de Direito da Fundação Getúlio Vargas e de especialistas como o professor Ricardo, que esteve conosco em vários dos debates, construir um projeto de pesquisa a partir do qual foi elaborada uma matriz de variáveis que serve para a identificação, avaliação e sancionamento do discurso do ódio a partir de casos concretos. Construímos variáveis a partir da análise de jurisprudência, bibliografia teórica e legislação relevante sobre o tema. E no estudo de cada um desses materiais, colheram-se novos elementos que pudessem ser inseridos de maneira estruturada na referida matriz. O projeto do discurso de ódio conceitua, então, como aquele que avalia negativamente um grupo vulnerável ou um membro de um grupo vulnerável, a fim de estabelecer que ele é menos digno de direitos, oportunidades ou recursos do que outros grupos ou indivíduos, membros de outros grupos, e, consequentemente, legitimar a prática da discriminação e da violência. Nesta curta abertura, não vamos ter todo o tempo para detalhar a matriz de variáveis e quais são os critérios que ela leva em conta para uma determinada situação, mas eu coloco à disposição dos organizadores do evento e da audiência o guia, o livro, a matriz, para que possamos, em conjunto, verificar a sua aplicabilidade e a sua adequação aos casos concretos, no sentido de construir uma alternativa para a regulação e para a autorregulação dos provedores de redes sociais. Temos como exemplo a legislação alemã, de junho de 2017, que entrou em vigor em janeiro de 2018, o Ricardo conhece isso melhor do que ninguém, prevendo multas em caso de descumprimento por parte de plataformas que não removam conteúdos claramente ilícitos em até 24 horas após a notificação. Então, o sentido da autorregulação, a necessidade, temos aqui várias políticas, seja do YouTube, do Twitter ou do Facebook, que recentemente têm revisto as suas próprias políticas, muito sob pressão da sociedade e dos governos para que atuem de maneira mais proativa, no sentido de moderar os seus conteúdos, porque temos visto as consequências absolutamente danosas que uma posição passiva vem trazendo. E no final de julho de 2018, tanto Facebook, Twitter, Google e YouTube encaminharam os seus relatórios para a autoridade alemã com os percentuais de atendimento e de remoção de casos. Assim, é importante considerar, e vou concluir, que as plataformas existentes na internet têm um grande mérito de revolucionar a promoção da liberdade de expressão e da informação, mas também, por se tratar justamente de ambientes normatizados, devem estar sujeitos às respectivas legislações dos países em que exploram economicamente os seus usuários mediante a prestação de serviços e devem ter a responsabilidade de garantir que o seu ambiente não se torne um porto seguro para ilícitos, em especial do discurso de ódio. Muito obrigado.
Thank you, Fernando, very much for your introduction. Would you like to present the first speaker, Professor Daphne Keller?
Yes, of course. Thank you, everyone. Professor Daphne Keller directs the program on platform regulation at Stanford Cyber Policy Center and was formerly the director of intermediary liability at CIS. Her work focuses on platform regulation and internet users' rights. She has published both academically and in popular press, testified and participated in legislative processes, and taught and lectured extensively. Her recent work focuses on legal protections for users' free expression rights when state and private power intersect, particularly through platforms' enforcement of terms of service or use of algorithmic ranking and recommendations. Until 2015, Mrs. Keller was Associate General Counsel for Google, where she had primary responsibility for the company's search products. She worked on groundbreaking intermediary liability litigation and legislation around the world and counseled both overall product development and individual content takedown decisions. Please, Mrs. Keller, the floor is yours.
Thank you so much. And I am honored to be here. Also, congratulations to Dr. Lottenberg on his appointment as the OAS Commissioner to monitor and combat anti-Semitism. That is an amazing tribute and such an important role. So Matthias and I have both written about what I call must carry rules, lawsuits or potential legislation that would compel platforms such as Facebook or Google or Twitter to carry content that currently they remove using their discretionary power under their terms of service. And it's really exciting for me to be here with him. We've actually never been on a panel together, even though we work on sort of two geographic sides of the same issue, with him writing extensively on the interesting developments in Europe. As a litigation matter, these lawsuits typically come from the far right. And in some cases in the US, lawsuits demanding reinstatement on platforms like Twitter have come from committed racists who want to be back on Twitter to spread a message of white supremacy. But I believe this is not innately a left-right issue at all. Indeed, there are people on the left or people who are concerned about racial equality who have also objected to the removal of their speech and felt that they should have a right to challenge it. In fact, the first time that I was aware of a legal effort to enforce something like a must carry claim was in Brazil, was when Facebook took down a photograph of an indigenous woman in the Amazon who was topless. And there was, I believe, an attempt to bring a human rights challenge before a commission in Brazil saying that the rights to indigenous identity and diversity had been violated there. So I bring that up just to kind of recenter us and get away from, I hope, from the idea that this has to be a political fight between the left and the right, because I actually think it is more, it goes deeper than that to the question of how we operate our society and what powers sit with public and private actors. I will start, actually, let me just say one other thing, which is, Matthias and I will talk, I think, mostly about the US and the European approaches to this. But I do think that Latin America brings its own special degree of sophistication and maybe possibility of other outcomes than might be seen in the US or Europe, in part because of Article 13.3 of the Inter-American Convention, which has sort of primed the legal system with the idea that regulation of intermediaries is regulation of speakers in a way that has led to extremely sophisticated work on this topic coming out of Latin America for at least 10 years. You guys are way ahead of most of the rest of the world. And so I'm interested to see where you go with this topic. I'm going to start out with a few practical observations, though, about what it would mean to have something like a carriage obligation for internet platforms. What is it that we want to see, we as a society, as lawmakers, as lawyers enforcing laws? What do we want to see on platforms when we go to them? Do we want to see everything? There are those, especially in the US, who advocate for something like a common carriage regime to treat YouTube as if it were the telephone company. This is often invoked, but it is, in my opinion, kind of a red herring, an idea that nobody would actually advocate for in practice if they thought they had a chance of achieving it. And this is in part because the speech that is lawful in the United States under the First Amendment includes things that are shocking to the conscience for most people and offensive and things they don't want to see when they go on Twitter or go on Facebook. It includes extremely violent threats. It includes Holocaust denial, which also is legally protected speech in a number of other countries. That's not unique to the US. It includes many things that offend the sensibilities of most internet users on the left and the right. And I think in any country with a strong free speech tradition, as is the case in many Latin American countries, you'll find a similar gap between what the law permits as a formal matter of constitutional rights and what society expects as a normative or moral matter about what public discourse should look like. And that makes it, to me, seem not very viable to promote this common carriage idea and say, oh, platforms should carry every single thing that the law permits. That doesn't lead to an outcome that most people want. Particularly, I should say, in an internet where whatever it is that Facebook and Twitter prohibit, there's somebody out there carrying the other stuff. It's not that it has no alternate channel to get across to people. So, but if we don't want this sort of cesspool, common carriage version of the internet, is there something else that we as a society nonetheless might want to compel platforms to carry if we can find a legal excuse to do it? Is there a portion of lawful speech that they should not be allowed to take down? And that approach of defining a particular category of lawful speech that they have either no discretion to remove or limited discretion, they have to check with a court, something like that, has come up both in Brazil recently with the executive order, or we would call it an executive order that Bolsonaro issued. It's also part of the UK's online safety bill. It has simultaneously the idea that platforms must take down not just illegal content, but an additional margin of harmful yet previously lawful content. So they have to take down more than the law used to require, but also they must leave up what they call content of democratic importance. So there's this new defined category of things that they can't take down. That, I think, intuitively appeals to a lot of people, but it does mean defining an entire new set of speech rules that is not what any court has ever had before or what any legislature has created, because by definition, we're talking about doing something that prohibits slightly more or slightly less, permits slightly less than any of the precedents that we already have. And it requires some institution that we trust to administer these new sets of rules. And I think all of the lawyers in this group can appreciate what an enormous and ambitious undertaking that would be. Do we establish a regulatory agency that is empowered to make this tremendous change to the law that governs what information we can see and exchange online every day? Do we trust that regulatory agency? Are we worried about regime change affecting that regulatory agency? Can we staff such a regulatory agency sufficiently that it could manage the operational burden of actually reviewing real-world disputes? And the UK's answer to this is no. The agency won't review any real-world disputes, and that leaves us in a situation where there isn't actually government review and administration of these brand new speech laws. It actually just sits with the platforms, which is the problem we were trying to get away from in the first place. So I am intrigued by efforts to move in this direction. I think in the US, they would probably be unconstitutional, although there are many, many efforts to challenge that interpretation of the Constitution going on. But I think in other countries, it could be constitutional to move in a direction like that. I am intrigued to see if anybody can actually execute on that in a way that is a net improvement and that doesn't create new threats to users' rights, both rights to be safe, to be protected, for example, from hate speech, and also rights to exchange lawful information. My overall take is that the better response to the current sort of crisis of platform dominance of discourse and of harmful content being spread and amplified by content, the better response is not to entrench and regulate that power, but rather to dismantle it. Don't change the rules that our current dominant corporate bodies enforce for speech. Instead, change the rule makers by diversifying who gets to set rules for speech and creating a wider array of decision makers and discursive universes. This is something that my Stanford colleague, Francis Fukuyama, has written about as middleware, the idea that you could take existing platforms and layer on top of them new competing entities offering their own content moderation or their own ranking services. So you could have the Disney flavor of Facebook. You could have the version of Twitter that is safer for female journalists because it more aggressively enforces against mobs that attack female journalists. You could have a Black Lives Matter flavor of YouTube. You could have something that reflects the values of your church, that is prioritized based on your interest in sports. You know, create many alternate versions on top of the existing social media platforms. This has a bunch of drawbacks and complexities, and I could talk for another hour about those, but I do want to put it out there as another way of thinking about this, in case we believe, as I believe, that the road of new speech rules and government regulation that entrench existing platforms might be a dangerous one. I will stop there because I want to have a lot of time for discussion. But I have so much more to say. But I am really looking forward to what Matthias says. So I will hand over the mic to him.
Just to make a remark, Daphne, before Fernando presents Matthias, you just mentioned a case, a Brazilian case, on this photography of indigenous woman. And this case was brought to the court, Inter-American Court of Human Rights, by a co-organizer of this event that we're making here.
Oh, amazing.
Yes. His name is João Brandt. And he's the co-organizer of this series of events. And at that time, in 2016, I think, he was working as secretary at the Ministry of Culture in Brazil, of Communication. And he brought personally the case to the court, just to make the remark. And then I give the floor for Fernando.
Thank you, Ricardo. Thank you, Mrs. Keller. Very challenging and interesting. And you put the kind of transversal observations of what we see and an American perspective and a Brazilian perspective. You also mentioned the recent executive order, the short-lived executive order by President Bolsonaro, who was reinstated now as a bill in the House of Representatives. So I think we have a lot to discuss after the presentations. I would now switch to Professor Dr. Matthias Kettemann, who has an LLM in Harvard and heads the research program, Regulatory Structures and Rule Formation in Digital Communication Spaces at the Leibniz Institute for Media Research at the Hans Bredow Institute. His team is concerned with the rules under which new forms and practices of social understanding and self-assurance emerge in digital communication spaces and especially in social networks. After studying law in Graz, Geneva, and as a Fulbright, I'm also a former Fulbright fellow and BOA scholar at Harvard, he completed his PhD with a thesis on the legal status of the individual in international law. In 2014, he was called to the Cluster of Excellence, the formation of normative orders at Goethe University Frankfurt, as a postdoctoral fellow, where he habilitated under Professor Kadelbach and Professor Vesting at the Institute of Public Law of Goethe University Frankfurt am Main, with a thesis on the normative order of the Internet, and received the authorization to teach international law, Internet law, and legal theory. After substitutions in Heidelberg and Jena, he followed the call to the Professorship for Innovation, Theory, and Philosophy of Law at the Institute for Theory and Future of Law at the University of Innsbruck in the fall of 2021. Mr. Kelman, the floor is yours.
Thank you very much. I think you've all now discovered my secret plan. As long as you make your job description as difficult as possible, you can do whatever you want to, because nobody actually does understand what it is that you do. So I'm working on regulatory structures. Where are they hidden? Well, they're hidden behind everything. They're hidden behind the way that platforms conduct business. They're hidden behind how states interact with platforms. And that, I think, brings us already to the key question. Right now in Europe, we are trying to navigate the responsibility of states to ensure the rights of their citizens, the ultimate responsibility that all states have, and the role of online platforms. They have an important role, undoubtedly. They have created communication spaces that have never existed in that form, in that force before. And they have not only created those spaces, they have also created a normative order, a legal order behind those spaces, based primarily on their terms of service, their community standards. And that order is closely connected to the way that it is being implemented. They act as legislators, quasi-legislators, as norm developers, and they also enact their values through content governance mechanisms based on human and algorithmic moderation. So you have to look at the fascinating field of content governance by differentiating between the norms which are being set by platforms and the practices which develop on those platforms. And you can't just look at them in a one-dimensional way. Now, the challenge that we're facing in Germany and in much of Europe is slightly different from the one that our dear friends and colleagues in the US are grappling with, because the freedom of expression in Europe does not carry the same let's say the same defensive power that it does in the US. Many laws, Daphne has written extensively on that issue, many laws that are being brought, many proposals which are being brought in Congress will just not meet the very high standards brought under First Amendment challenges. So this is different in Europe, this is different in Germany, because in Germany for quite some time we have accepted that certain rights and obligations are also applicable between private parties, and that private parties can be regulated through the horizontal application of human and fundamental rights. It is therefore, at least in Germany, not so much a question of must carry, but rather of the conditions under which platforms can be, let's say, platforms are limited by the law and by judicial institutions in how they govern themselves. And the interesting approach, and I think this is really an innovative approach and an important approach, is that courts, at least in Germany, over the last 3 years, have not so much focused on the content of the speech, but rather on the frame, on the normative frame under which platforms act. So, for instance, briefly written about that a bit. In one of the last cases, the Federal Court of Justice has confirmed, in keeping with long-standing jurisprudence, that platforms have a right to develop their own standards, to apply their own standards, as long as they meet certain important framework conditions, such as making sure that especially heinous speech is taken offline within a very brief window of time. That's the famous Network Enforcement Act with its with its two deadlines of a day and 7 days. But apart from that, platforms have quite broad leeway as to how to deal with online speech. Now, what the Federal Court also says is that because of the special role, the special importance that those platforms have for online discourse, they can't just do whatever they want when it comes to implementing their standards, their terms of service. This goes back to a long trail of cases involving offline settings with great names like the beer can flash mob case and the Frankfurt Airport case. In all those cases, the Federal Constitutional Court, for instance, has said that as long as one party is especially powerful, human and fundamental rights have to be applied to that party, also with regard to their relation with other private actors. And the cumulative conditions under which we are right now obviously fall under such a special case, a special circumstance. Now, I think the Federal Court of Justice has done something rather clever, at least in the July decisions, which I've briefly discussed in a short piece in Lawfare. Namely, the court said, as I've mentioned previously, yes, platforms can set their own rules, but no, platforms are not allowed to just implement them whichever way they want to. In implementing their rules, they have to meet certain procedural conditions. Among those procedural conditions, informed by fundamental rights, is the principle of equality. So platforms cannot just pick and choose. They can't just say, we'll enforce that provision against certain groups and against certain individuals, but not against others. That, of course, is quite a challenge for automated content governance, which doesn't necessarily ensure that its content governance prowess is being applied equally to everybody. The court also said that it is important to ensure that the strong power differential between the big platform and the small user is being given a countervailing force, and that force is a duty of the platform to inform users about the deletion that is being taken place or the downranking that is taking place, at least ex post, or even if it's an account deletion that's being envisaged ex ante. One of the most famous recent cases of a deplatforming, namely the one of RT Germany, the Russian foreign news agency, which had the fourth largest YouTube channel in the German language. And everything we know up to now has not been legal under that approach, because RT was not informed previously of the impending account deletion, as far as is known. Now, courts have picked up on that approach. Just a couple of days ago, the Landgericht in Cologne, the District Court of Cologne, made YouTube reverse two video suspensions, because according to the court, YouTube had not given the authors, some corona deniers, sufficient reason, including a referral to a specific clause in their terms of service, why their videos had been deleted. So the courts, and this is now the second or third coming after the Federal Court of Justice's July decision, are saying you have to ensure that people know why certain stuff is being taken down, and if you don't do that, we are going to reverse your decision. And you can quibble with the details, but I think the general tendency to make sure that there's a more rule of law within platform decisions is a positive one. Now, immediately you will see the problem. What about deletions of spam accounts? Obviously, we want problematic accounts that target individuals, that spread harmful content to be acted upon. But how do we apply the rule to those kind of platforms? Do we really want to have every single platform, every single account that engages in authentic coordinated behavior, to take up a term coined by the platforms themselves? Do we want every single account informed before it's being deleted so they can sort of save their fans and move somewhere else? Do we want that? That, I think, is a serious open question. I don't think we'll see lots of cases of those kinds of accounts coming before the courts, because obviously those kinds of people who run those accounts will most likely not engage in a long-lasting legal battle to save their investment like that. They usually will just go somewhere else. But I think the question at least has to be asked: how do we deal with those kinds of accounts? And all of this is taking place against the background of 4 horsemen of the non-apocalypse, sort of which are running from Brussels towards European capitals, namely the Digital Services Act, the Digital Markets Act, the Data Governance Act, and the AI Act. So 4 interlinked, mutually reinforcing new acts, which are going to, I think, greatly impact the way that we deal with platforms, platform power, and the tools which platforms use. There also important elements include a duty to inform users of if their content is being acted upon, a duty to disclose certain algorithmic recommendation principles, a duty to ensure an independent audit. So a lot of capitals are seeing that those rules rather positive. However, at least Germany still wants to keep its Network Enforcement Act, which is going to, rather sooner than later, is going to lead to certain European Union law issues, and we see in Poland that those issues don't always get resolved in a way that's conducive to more rule of law. However, I think we see a trajectory which is basically positive, namely towards more rule of law in online platforms, and European lawmakers are, of course, following the debates which are currently going on, the disclosures, the whistleblowing, which I think that most of us who engage with those issues on a daily basis are not completely surprised by those documents. It's just it's nice that this is being looked at again. We could have told most politicians most of the things, but it's of course always great to have all of this together and to have this focus on platforms. But I do get the feeling that German media asks me the same questions like every couple of months after each new whistleblower. But I think it's important to keep on that, and ensuring rule of law in online spaces is an uphill battle that's going to stick with us. That's why I just wanted to say intergalactic, but of course it's transatlantic exchanges are extremely important, because we learn from each other, and if there's one thing we can learn from Daphne and her work, is that creative thinking on how platforms should be ruled is extremely important for making better rules. So thank you for that, Daphne. Thanks for this for the great organization to put us together.
Thank you very much, Professor Kettemann. I think you brought very interesting insights, especially that we are usually used to focus on the contents, and we should be more attentive to the frame, as you mentioned, and to the behavior of people, or to the bots that online tend to apply some kind of attitudes and posts that the courts and the regulators should care about. Here in Brazil, at the electoral court, in one of the interactions they had with the providers, the emphasis was given more on the behavior of the persons who act on the social media rather than on the content. And it was effective to a certain level that it was able to remove or to moderate some contents of fake news that could interfere in the electoral results. So thank you very much. And we will move to Professor, and I'll switch to Portuguese, Juliano Souza de Albuquerque, Maranhão. Um prazer de conhecê-lo há tantos anos. É professor associado da Faculdade de Direito da USP, é pesquisador da Fundação Alexandre von Humboldt e professor convidado na Universidade de Frankfurt. Fez seu bacharelado, doutorado e livre docência em Direito pela Universidade de São Paulo e foi pesquisador visitante nas universidades de Miami, Leipzig e Maastricht. Pós-doutorado na Faculdade de Ciência de Computação da Universidade de Utrecht, na Holanda, coordenador e editor da Revista Brasileira de Filosofia, atualmente desenvolve pesquisa nas áreas da teoria do direito, lógica deontica, teoria da argumentação, inteligência artificial e direito digital. Por favor, Juliano.
Okay, thank you very much. Thank you, Fernando. I'm going to speak in English because I want to provoke some discussions with Daphne and Matthias. I want to take this opportunity of having both together to hear from them about this issue, which is very heated now in Brazil, the discussion on content moderation, particularly on the regulation of content moderation. As Fernando has said, the executive order by the president was short-lived, but it it revived the discussion already that took place in 2020 on a bill of regulation of transparency in the internet. And there was in this discussion some evolutions regarding the regulation of content moderation, some advances. Although, as I'm going to indicate, there are some limitations on that proposed bill. And it's nice to have you here to promote this discussion, because one of the goals of our institute is to circulate ideas of the state of the art on these matters. And also we are really engaged in this discussion with the parliament. We have the opportunity to have deputies and senators in our meetings, in our seminars. And also we have discussed the content of that bill with the cabinets of some deputies and senators, always trying to provide information and technical content about the discussion, mainly the discussion which is going on in other jurisdictions and the advances that are brought about in other jurisdictions. So this is another chapter in this effort, and what I'm going to do is to just bring a scenario, what's the core points of discussion in the Brazilian bill. So the present state in Brazil regarding content moderation is the Brazilian law on the internet, the so-called Marco Civil da Internet, which has a core rule on the responsibility of platforms, of internet platforms, which is a safe harbor. They are only obliged to take down content if there is a judicial order to do so. So the platforms are permitted to moderate content according to their terms of use, but they are not obliged to do so, and neither there are any procedures that should be obligatory or responsibility for spontaneous moderation of content or accounts in the social media, in the social networks, or platforms. So this is the present state, and the bill, which is proposed here in Brazil, is clearly influenced by some principles in the international discussion on the regulation of content moderation. For instance, Santa Clara Principles, the Electronic Frontier Foundation principles, and the German NetzDG law on social networks. There is a clear influence by these documents, and the proposals on content moderation are basically concerned with transparency measures to disclose the numbers of the moderation activity, the duty to notify those users that are subject to some intervention by the platform on content moderation, and to provide an opportunity for revision of the decision by the platform. And these are already present. These measures are already present in the proposed bill. Although, as we have indicated, they are, according to the present literature on the issue, they are insufficient. They are nice advances because they presuppose some procedural responsibility by the platforms, but they are insufficient because they all refer to good practices after the application provider has made the decision about a measure on content or on accounts. It's all about what happens after the decision was taken. But of course, there are concerns about the adequacy and impacts on fundamental rights arising from the very decision-making process adopted by the platforms. And this decision-making process regards basically the teams of moderators and the use of computational tools for automated content detection and classification and decision-making. So there are two main aspects that should be of concern regarding the decision-making process, the team of moderators and automated decision-making. Regarding the moderators, there are two main points that we emphasize. We have recently, I think 2 weeks ago, we have in the Institut Legal Grants issued a report making proposals about the bill, and one of the proposals regards exactly transparency about the decision-making process regarding content moderation. One of them is about the moderator's competence to deal with local issues, and I refer to the episode in Myanmar, where there was an inability to detect hate speech and very deleterious content because the team at Facebook was not competent enough to deal with local issues or even the local language. So there must be transparency about the team of moderators that are in charge of the decisions in the daily basis, not only as has been proposed and successfully carried on by Facebook by having a global oversight board, because this oversight board it's very useful, but it only decides a limited amount of cases along the year. And there must be transparency also about the local teams that are responsible for the decisions about the content or about accounts. The second aspect of the moderators is the moderators' working conditions, because these moderators are exposed to very degrading images and content, and there should be also concerns about their ability to carry on this work on healthy working conditions. Regarding automation, there has been an over-reliance on these tools, on the use of artificial intelligence to classify and take down content. Actually, the regulations that are in force somehow induce the platforms to use these tools because they have a limited, very short time to react, sometimes 24 hours or 48 hours. So they have to use, considering the amount of users and of postings, they have to use automated tools to detect and classify this content and make decisions about this content. But there must be also transparency about these tools to prevent excessive blockages or to provide information about the criteria relevant for the classification used by these automated systems, the level of accuracy, and the possible incorporation of discriminatory social traits or distortions in accuracy according to gender or race. So another proposal that we are promoting and discussing and circulating within different forums is that there should be more transparency about the algorithms that are used for content moderation. And this also is important because it's here in Brazil, another bill on AI, on ethics and regulation of AI is under discussion, and it's until now a little superficial. So these issues must be taken into account and should be discussed together because they are interrelated. And one last point that I would like to make is about another limitation regarding this regulation. Even with these additions on the team of moderators and transparency about the algorithms, all these initiatives are in the sense of protection. They are protective mechanisms, either for preventing unwanted content to be in the media, or to prevent or to protect those affected by the decisions on content moderation that were unduly restricted. So they are protective measures. Nevertheless, there is also a concern that is not encompassed by these protective measures, which is relevant with respect to the diversity of opinions that the users of the platforms are subject to. There is an interesting remark by Stuart Russell in his recent book, Human Compatible, about the control of AI, where he makes an example on social media. And he says that the design of these algorithms for the distribution of content in social networks was intended to satisfy the user's wants and desires and needs. But the way that these algorithms capture these needs was by measuring the level of involvement or engagement of these users. And so the artificial intelligence, instead of learning what users want, they have learned how to make the users predictable. And they learn to do that by sending repetitive content or sending content that is not diverse enough, so that this generates further engagement. And we know the prejudicial effects that these algorithms have on the polarization of public debate and the public sphere. So it would be interesting that the regulation also could find ways in order to warrant not only protective measures, but also enabling measures. And by this, I mean measures that enable that the user receive a sufficient amount or level of diversity of opinions in the automated distribution of content in the platforms. So, and what I want to, sorry.
I think we need to go to the discussion because
yes.
we make an agreement that we'll finish in 1 hour and 15 minutes.
Yeah, but I'm just finished. This is my provocation. I'd like to hear Daphne and Matthias about alternatives for not only for protective measures, but also for enabling measures.
Daphne, maybe we can begin the discussion with your question, with your response and your question on Matthias.
Sure. So I think enabling, that's a really useful framing to talk about enabling measures. And I do think that things like better transparency is an important step in that direction. I think that researcher access to data is also incredibly important because many of the things that we, as a society or as academics most want to know about what's going on inside of platforms, you can't understand it without seeing some private information, without seeing posts that were shared in private groups on Facebook, for example. And so there are some things that unfortunately, can't become publicly transparent for the really sort of open source research efforts that I wish we could see. But for those things, we need to find ways to get academics in there or get some kind of vetted researchers to really be able to look and see what's happening. So I guess I would also think of the middleware idea as enabling users to make their own choices and assert their preferences and turn the dials and knobs to say, I want more cat pictures and less violence, or whatever their individual preferences may be. To move on to my question to Matthias, Matthias, you mentioned that the German court framing involves saying that platforms and their relationships with users, this very unequal relationship where the platform has almost all of the power, the law can correct for that in some ways. And one of the things that the law can make them do in Germany is respect principles of equality, which I think you said meant you can't enforce rules against one group, but not others. And my question is, does that mean equality as between identity groups, equality regardless of race, religion, gender identity, those kinds of things? Or does it mean equality as between political groups, meaning that you treat every kind of political speaker the same way? Because if it means that second one, it seems to me that we are back to the question about regulating speech. Because, certainly in the US, not to use an extreme example, but this is one of the examples sort of counted by the people claiming conservative bias. Is the American Nazi Party a political party that can assert a right to speak equally on the platform? Who counts as a legitimate speaker under, or a legitimate message under that rubric? And I think it's a very big picture question. It's absolutely coming up in the US right now. The far right is being quite cynical, but in my opinion, cynical, but maybe very effective in taking legal precedent that is about race that's about civil rights, that's about equal access to places of public accommodation, and saying, oh, actually, this means that I can go and spread a white nationalist message because you have to treat my message equally to other people's messages. So the core of my question is the equality that you're talking about equality based on identity, such as race, or equality based on treating different political messages equally?
Well, it's even more nuanced than that. At the same time, less nuanced, because the courts don't look at either of those issues. They look at individual users. They're just telling platforms, you cannot start enforcing certain of your standards against individual users if you don't enforce it against other users. You have to treat users equally. So it's not dependent on what kind of speech is being said. And we've had a very similar case. There's no Nazi party, obviously, but there are right-wing parties which are being watched by the federal Bureau of Investigations. One of them called the Dritte Weg, the Third Way, and they were the party that brought the case in front of the Federal Constitutional Court 2 years ago because their account was suspended. And the court said that in that individual case, Facebook just made a wrong call, and that particular piece of content didn't violate their own rules, and also Facebook couldn't just withdraw the account, arguing that they might violate the rules in the future. They have to treat that one party just as they have to treat other individual users. Even though it was perhaps more likely to violate the norms in the future, but still, terms of services should apply to all users. So we don't have the same
What does that mean?
What does it mean?
Is it if another user said the exact same thing as you, then they get the same outcome, or does the court have to look at a body of data about similar statements?
Well, no. What it means is that platforms have to implement their terms of service, and if the terms of service say that accounts can be terminated for certain violations, they have to show that those violations have taken place. Perhaps my formulation, treating users equally, leads sort of engages a different kind of discourse in the US than it does in Germany. What I mean by that is that, as I've sketched, the courts are saying that the terms of service have to be applied equally across the user base, and any decisions have to be taken on the basis of facts, and have to be given. Reasons have to be given why accounts are being terminated, why content is being suspended.
Thank you.
Maybe just to make one last short point, we have now 3 minutes as agreed. Matthias framed a really interesting way. So I'm a Brazilian that is lecturing in Germany, so I'm quite. It's a quite a common way of framing this question, putting the fundamental rights in the middle of the question. And Daphne, at the other side, puts in the way that Americans frame the situation or the constellation, in the sense that the fundamental rights is not at the beginning, the middle of the discussion. No? What would you, Daphne, say about this approach? So departing from these horizontal effects of human rights, fundamental rights, is this more maybe dangerous for example, one fundamental right, freedom of speech, or private autonomy of private parties? What would you say about this typical? It's also in Brazil, we talk a lot of this, so departing from fundamental human rights in these questions.
I don't take issue with that approach at all. Like I think that is a very useful approach. I would be happy to see a more horizontal application of fundamental rights in US jurisprudence. I do think that in the the way this gets discussed in human rights discourse sometimes leaves open a really important question about when we want private companies to respond to the kinds of human rights constraints or rules that apply to governments, and when we don't. Like, when do we want them to respond to market forces, if ever? Presumably sometimes we do. And so, like, how do you sketch out which parts of their operations fall in which bucket, the fundamental rights bucket or the, you know, market forces are okay bucket? But I think it is a valuable approach, absolutely. But I remain confused just about what the German approach means in practice. You know, how you resolve individual cases. Like, does it ultimately just boil down to the same kinds of procedural obligations on platforms to have clear rules and notice and appeals and so forth, as Juliano was talking about in his remarks? Or is there some substance to it? And if there is some substance to it, like, how do you even litigate about that and get to reasonable outcomes without some kind of massive discovery into the whole operation of the platform?
I think it's sort of a middle way, right? You know, platform in none of the cases did any larger discovery have to take place. Also, we don't do, you know, discoveries. I mean, we do kind of discoveries, but not in the same way that you know from the States. Cases are looked at individually, and when I mean by equality of treatment, I really do mean only that the rules are applied as they're written down. You cannot make the argument, of course, that let's say a similar user has posted something similar, and because that has not been taken down, yours also should not be taken down. But you can make the case that what you have said doesn't fit a specific clause within the terms of service, and therefore your content has to be reinstated. I mean, platforms hate those kinds of things, obviously, because it takes a lot of time, and it's just, you know, one drop in a bucket, which they have to litigate up and down. I think the larger questions, which we're perhaps not focusing enough, is, you know, how this influences the practice of platform governance, and obviously this attractivizes a, let's say, more hands-off approach in a way, because, you know, people usually don't litigate if something stays up, right? They litigate if something gets taken down. So whenever, you know, I'm sort of torn, right? I mean, I'm a big fan of nice judgment you can write blog posts on, but those judgments will also make platforms be more careful in content. They will exercise more moderation in content moderation, and I'm not sure that that's always the best thing for a sustainable platform communication economy.
Daphne, would you like to say final words, or Matthias, and then we can finish our panel?
I think I have said enough, so I will hand off the microphone.
Okay, and you, Matthias?
I think we have to talk to each other. We have to continue to talk to each other. We have to continue to learn from each other. There are interesting innovative initiatives coming from smaller platforms, from niche platforms. We haven't yet found out enough about explainable AI in content moderation. We haven't looked enough and deeply enough into community-based moderation. We need more data, and this field is going to continue to employ us and feed our children.
Thank you, Matthias. Thank you, Daphne. Thank you, Fernando. Thank you, Juliano. It was a really nice talk today, conversation.
And it was, Ricardo, really, really nice to have Daphne and Matthias now, to know Daphne virtually, at least. And certainly we are going to engage you in our initiatives for the discussion of the Brazilian bill.
Yeah, for us, it's really important not that the Brazilians create from the zero, from the beginning, new regulations, but it's important to bring from all of the world the best practice, because all this regulation will affect fundamental rights, individual rights, and we would be glad to have you again in the future in our discussions with us. Thank you, everybody.
Thank you.
Thank you so much for having us.
Thank you very much. Bye.
Bye.